So good morning. Can you see and hear me?
Yes, I can. Thank you.
Thank you very much. As you know, you directed this hearing today to investigate a series of disclosure failings by the Post Office and also to hear evidence about what has been done to put those disclosure failings right. The inquiry asked for 5 witnesses to produce written evidence and duly received 5 witness statements from those witnesses. You'll hear evidence from 4 of those today. Fintan, Canavan, who Mr. Blake will be asking questions of firstly, Diane Wills, who I will be asking questions of, Paul Tombleson, who Mr. Blake will ask questions of, and then finally Greg Rowan, who I will examine. The 5th witness was Mr. Ben Fote, from whom you heard previously, the Post Office's General Counsel. The inquiry took the view, as a result of reviewing the contents of his witness statement, that more meaningful and detailed evidence could be obtained from the other 4 witnesses that I have mentioned, and therefore he is not to be called today to give oral evidence. His witness statement will be uploaded, as will the other 4 witness statements, to the inquiry website today. So, sir, can we start then, please, with Mr. Blake and Mr. Canavan?
Certainly, but can I just make sure that I'm up to date with the documentation? I received this morning a letter or an email from Mr. Henry, which he sent in the middle of the night, and I received further information in a letter from the Post Office, which arrived at 8:20 this morning. Am I up to date, Mr. Beer?
Yes, you are, sir. The 3 a.m. email from Mr. Henry was itself a response to a 22-page letter received from the Post Office yesterday, which
Yes.
the inquiry distributed. And in summary, Mr. Henry says it's difficult to digest complex 22-page letters on the eve of a hearing. Please, can you impose a deadline in future that the Post Office should, if they wish to update the inquiry with information, do so not less than 48 hours before a hearing. And then the 8:20 a.m. communication this morning is an amended version of a table that was disclosed at 4:26 p.m. Yesterday. You are up to date, sir.
Thank you. All right, then over to Mr. Blake.
Thank you.
Thank you, sir. Can I call Mr. Canavan, please?
Yeah.
I do solemnly,
sincerely and truly,
declare and affirm
that
the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Thank you.
Thank you very much. Can you give your full name, please?
Fintan John Canavan.
Mr. Canavan, you should have in front of you a witness statement dated the 22nd of August 2023. Is that correct?
It is.
And if you turn to the final page of that statement, can you confirm that that is your signature? It's on page 17 of 17.
It is.
And is that statement true to the best of your knowledge and belief?
It is.
Thank you very much, Mr. Canavan. That witness statement will go onto the inquiry's website. Its unique reference number is WITN 099700100. It doesn't need to be brought onto screen just yet. I'm going to start just by asking you a brief career history. You're a qualified solicitor, and I think you've been practicing for over 30 years. Is that right?
That's correct. I was admitted into the Law Society of England and Wales. I then transferred and I'm admitted to the Law Society of Northern Ireland.
You've acted for core participants in a number of public inquiries, including, for example, the Bloody Sunday inquiry.
That's correct.
You're currently a partner at DAC Beechcroft Solicitors and have been in that position since September 2020. Is that right?
That's correct.
In July of 2021, you were asked by a colleague whether you'd be willing to be seconded to the Post Office to assist with their internal inquiry team. Is that correct?
That's correct.
Were you aware at that stage, so in July 2021, that on the 1st of June 2021, the previous month, the terms of reference for this inquiry had been announced?
No.
You were eventually contacted by the Post Office in October, is that correct?
It was around October, yes.
Were you aware that over the course of the summer before that October, before you were contacted, the Post Office and 218 others had become core participants in this inquiry?
No, I had not followed the inquiry at all until I actually became involved with it.
And when you were contacted in October, were you briefed on that kind of background? So, for example, by October, a provisional list of issues had already been published, including some 184 issues.
No, I had a number of phone calls with parties from the Post Office, and it was much more about my own background, what my understanding of inquiries was, what my experience with inquiries had been, and to indicate that the Post Office needed some assistance with an internal team to assist the inquiry. But we hadn't got into any discussions about what the extent of the inquiry itself was at that initial point.
Did you know why it wasn't until October of 2021, so 4 months after the terms of reference had been published, that you were contacted?
No, I had been contacted in July. I think one of my colleague in London who had done some work with the Post Office, had indicated to me that there was a desire to bring somebody in. I indicated I would be happy to do so, and then it was a number of months later when the actual contact to see if I would be available took place. So no, there was no discussion about what had taken place during that period.
And how long after the phone call did you actually join the Post Office team?
Probably within about a week or so. There were a number of calls. One initially with the Mr. Mark Underwood, who was the compliance director. I can't remember his exact title, but he worked in the compliance team. And then a second call with Mr. Fote.
Your title was Inquiry Director, is that correct?
Correct.
And you've spoken about Mr. Fote. You reported directly to Mr. Fote, who was the General Counsel, is that correct? And although you are a lawyer, you weren't actually acting in a legal role, is that right?
That is correct. It was quite clear. I wasn't SRA registered at the time. I am admitted to the role, but I wasn't SRA registered, and discussion was clear that my role was the inquiry director. The legal advice and legal representation was by the external firm, who were identified as Herbert Smith Freehills.
Can you briefly talk us through where you sat within the company in respect of, say, the group executive, various steering committees, and the external legal firms?
Without trying to get into a very detailed description of the general executive, Mr. Fote was a member of the general executive, and I reported directly to him. So the inquiry team was based in Mr. Fote's area, the sort of the legal and governance side of the business. I chaired the inquiry steerco, which initially met every week. Or in fact, it would have met as much as we needed it to meet, but it was listed for a hearing or meeting every week. And on the steering committee were a number of GE members. It was chaired by me and then was attended by whoever needed to attend. So there would have been inquiry team members. HSF would have attended on a number of occasions, Peters and Peters. As and when an issue arose, the relevant people were invited to attend. That would have sat regularly. I would also have sat in the Freedom of Information, the FOIA steerco, but my role on that was as a secondee into that role. I didn't have any voting or quorum rights within that steering committee. My role was to ensure that if we were aware of information that might be relevant to a Freedom of Information request, or if a Freedom of Information request addressed something that we would need to be aware of, there was a link in that regard.
You've mentioned two external legal firms, Herbert Smith Freehills and Peters & Peters. What do you see there, the difference between their two roles?
Herbert Smith Freehills were the lawyers representing Post Office with the inquiry. Their role was to advise, to link between the Post Office and the inquiry team. And they were our advisors and representatives. Peters & Peters, as I understood it, they dealt with a lot of the prosecutions historically. They had a lot of material available in regard to the prosecutions, and they would have assisted particularly in regard to that aspect and the phases which would have dealt with prosecution decisions.
You've spoken about the various steering committees, the group executive, etc. Was there anyone other than yourself with significant experience in public inquiry work?
Not as far as I'm aware.
I want to ask you about the length of the inquiry. You've said in your statement that it was anticipated the inquiry would only last for 3 to 4 months. Who was it that told you that?
That was the indication when I was contacted in July to see. I have a fairly substantial caseload. My background, I do a lot of legacy litigation and public inquiry work, so I had a fairly extensive caseload, and the indication was to me that it would only be 3 or 4 months, so there would be no need for me to try and offload my caseload or to try to make arrangements within the practice. And then when I spoke in October, I think the anticipation still then was that it wouldn't be running for an awful lot longer than that. So initially when I came in, I did not make any arrangements or alterations to my caseload, and I was still trying to manage that.
Who was it within the Post Office that gave you that impression?
My conversations were initially with Mr. Underwood and with Mr. Fote, and those initial discussions were along that it wouldn't be a long period of secondment within the Post Office.
And did you have a conversation then about retaining your current caseload?
Only internally within the business, that I had to speak to my line management team to make sure that there was sufficient cover if court hearings, whatever came up, that I would not be able to attend those. But that discussion was internal, it wasn't externally with Post Office.
Given the experience that you have had, for example, the Bloody Sunday inquiry lasted 12 years, did you think that that was a realistic time frame?
Initially, I didn't question it because I hadn't had any involvement, so I wasn't aware of what conversations and discussions had gone on. I wasn't aware of the extent and nature of the matters under this inquiry. When I first came in, within a very short space of time, it was quite clear that the team we had was too small, that the expectation of time was too small, and that the budget we had was just too small, that it was always going to expand, and that even initial expansion expectations were too short.
You address this to some extent in your witness statement. I'd just like that to be brought onto screen. It's WITN 099701000. And can we look at page 2, the bottom of page 2, it's paragraph 8, please. You say there, it was immediately apparent that the scope of the inquiry, the period under investigation, and the issues involved meant that the anticipated timescale and the team within Pol was inadequate. This created an immediate issue with the budget provided for this project, a theme which underpinned much of the work in the following 15 months. You say there it was immediately apparent. Was that just to you or to others as well?
Well, no, with the conversations we were having, that was one of the initial discussions that we would have had, that this isn't going to work. 3 to 4 months was not going to be sufficient. There was no way that, bearing in mind the inquiry hadn't even started having hearings, we were not going to complete sort of January, February of the following year. So that did become apparent very quickly, and steps were being taken very quickly at that point.
Did it come as a surprise to those who you were having those conversations with?
I don't think people within Post Office understood the nature, and that's not a criticism of within Post Office. I don't think many people understand the nature of an inquiry as opposed to a trial. in that a trial can be listed months in advance for 5 days, maybe goes to 6 or 7, but you know what your timescales are. Inquiries, by their nature, are much more fluid, and I don't think there is an understanding of the nature of that fluidity and the organic nature of an inquiry, which can change direction simply because of information which comes to light. So I don't think it was understood, and I think it did come as a surprise to those within the management level of the post office as to the extent that the inquiry could expand and how long it was going to take.
Moving on to budget, and I'll take you again back to your witness statement, paragraph 13, that's page 4. You say there, as the inquiry developed and grew, the issues around the projected budget and the need to secure a higher budget became the core focus and took up a significant part of the time I spent in the role. A very significant amount of my time was spent amending budgets, forecasting and projecting different scenario budgets, seeking approvals for increased budgets and drawdown, discussing ways to reduce fees with HSF, and looking at ways to achieve the same outcomes at lower cost. This meant less and less of my time was spent on the actual processes themselves. Can we turn over to page 13 and paragraph 50? So later on in your statement, you come back to the theme of budget. And you say you're addressing there the rectification of legacy document storage, and you say it doesn't feature highly in the priorities of any area, and there's a degree of passing the buck, hoping other areas will take up the responsibility. You say, again, this goes to budget allocations, and the need for those heading each business area or sub-area within those work streams did not allow for much leeway to allocate staff, time, or money to document retention, identification, and storage. And further down on paragraph 52, you say, you give an example of the storage facility in Winchester, and you say that much of it hadn't been accurately indexed, requiring manual searches of high volumes of material. Boxes were found to contain lottery receipts, memos, advertising brochures, all in one space, and if time and money were available, much of the material could be reviewed and destroyed, but that is not possible. That can come down, thank you. In your view, were there sufficient funds available at the post office for a comprehensive disclosure exercise?
I actually don't think that's a simple question to answer, in that the inquiry's budget came from within the general post office budget. The general post office budget was partially controlled by the government department, but partly they were a private company who had to generate a certain amount of their own income. And projecting budgets, I don't think that any business could have anticipated the expenditure that would have been needed to rectify years, decades of document disclosure. And I have a lot of sympathy for those within the post office themselves who were expected to run their departments, continue the operation of the post office, but then also find time and money out of limited budgets to assist me in finding other documents. I think, in short, no, there wasn't sufficient money within the post office to both run the business and deal with the legacy aspects that were highlighted during the process of the inquiry.
Mr. Canavan, you talk about the process of the inquiry, but there had, of course, before that been Court of Appeal proceedings, there had been the group litigation. All of those required disclosure to the courts. Looking back at the funding that was in place for simply maintaining and resourcing the document management within the post office, do you think that there was sufficient resourcing? And if not, why not?
No, I don't. I think that possibly the consideration hadn't been given to the legacy of material that existed. And I think that example of when we were required to go into Winchester and we found thousands of boxes which hadn't been indexed at all, other boxes were indexed inaccurately, and when you started going through it, the material, and I think in a way the defects have assisted this inquiry. Had there been a proper process of document retention, disclosure, organisation and destruction, many of these documents would have been destroyed within a policy of destruction after, say, 10 years, because material was no longer used. A lot of that material, had it been retained in a structured way, may not have existed now. But I do think the issue of document identification, location and storage is not a priority. And it may well be now because of the issues which have arisen, but I don't think it was. And I think the issues that we identified with boxes being found in different offices and different storage areas highlighted that there wasn't an understanding within the business as to where all of their material was stored.
And in your view, who was responsible for that?
I think it's a legacy thing. Just to say that who was responsible, you would need to go back to when the material was being initially stored. So go back to the Royal Mail period, where some was in the Postal Museum, some was in Winchester. The material we found in the Londonderry Crown Office, which, as I said, from my memory, when we had the safes cracked open, predated Horizon. So that was material that people didn't even know they had. So I don't think you can blame or allocate responsibility to a small number of people. I think it is a legacy across all of the running of the business. But I think ultimately the general executive should have an understanding of what material is in their business. And I say that in a global context, not as a criticism of any member of the current general executive who have inherited this issue as opposed to created it.
Looking at, for example, the corporate record keeping, in broad terms as an organisation, can you describe the state of the repositories that you found?
Well, I have no personal involvement. I didn't actually attend any of the sites. The reports that were coming in that to us would suggest that there wasn't a single repository of any particular material. So it was scattergun in its storage. That I think the core corporate material, so the board meeting minutes, we did see, from memory, I think we were able to find those fairly easily, in that they were, the older ones were in the Postal Museum and many of the others were then locatable within the company secretariat.
You've described in your witness statement fractured and disjointed. Can you elaborate on that a little bit?
Exactly what I'm saying, where you have some material in the Postal Museum, you have some material in Winchester, you have some material that was in Finsbury Dials, you had material held in large regional post office hubs, and there wasn't a single point of contact where you could contact one person and say, I'm looking for A, B, and C, and they would be able to say, that's stored in this location. It did involve then having to conduct very widespread searches physically and electronically to try and locate material.
This inquiry had been on a non-statutory footing for quite some time, and then in June of 2021 the terms of reference were announced as a statutory inquiry. You joined in October of that year. When you joined, were efforts already in place to try and improve the situation, or were you the first to make the suggestion?
I think it was an organic process where, as the requests came in for material, the level of disjointed storage became known, and it wasn't apparent immediately that from day one you had arrived. And when I arrived, my first core objectives were that the team was too small and the budget was too small. So we weren't hit immediately with a lot of the disclosure requests. I think maybe some of those came in around December. I remember there were some around December. But I think at that point, even then, we were more internally concerned with getting the team in place, and a lot of the disclosure requests were dealt with externally.
Were you aware, for example, that Mr. Justice Fraser in the group litigation had made criticisms of Post Office's disclosure?
I had read the judgments, the two core Fraser judgments, so I was aware that there was criticism of that.
And had those criticisms permeated throughout those who you worked with at the Post Office?
Yes, it was. The issue of disclosure was very prevalent. It was a high priority within those that I dealt with. And I think I raised the point in my statement where discussions took place about how did we ensure that there was no issue on disclosure, and there were suggestions of should we not just hand the keys to relativity over to the inquiry so that they had access to everything, or can we not just, if they want boxes from Winchester, can we not just bring the boxes so that there was no suggestion of anything being hidden? And that was not appropriate. It's not appropriate because the inquiry does not have the resource to go through that amount of material. But likewise, there would be a concern that there was an attempt to hide information by simply blizzarding the inquiry with disclosure that they would miss material. So it was understood that there was a duty on us to provide everything the inquiry wanted to see, and there was a clear desire within the GE members that I spoke with that we did need to make sure that you had everything you wanted.
Given that there was that desire, why was it that it wasn't sufficiently funded?
I think you can only make money go so far. The Post Office's budget was, as I understood, there's a government set budget. The Post Office has specific duties and responsibilities that they have to comply with. They have to keep a certain number of post offices open. They still have to recruit, train postmasters. They still have to replace the Horizon system. So there was an element of prioritising, and there were efforts to move budgets, and that was a constant theme throughout my time was how much money does the inquiry need? How much money does the inquiry team need? Where can we find the money? And messages going out to the BAU departments that if there were processes that they could stop and save money, they should do so. But it was they only had a limited budget that they could apply to the entire inquiry process. That budget had to cover not only the document retention, but the inquiry team, HSF, Peters and Peters, maintaining the relativity platform. That all came under the same budget. So finding extra money to do investigative processes such as going out to Winchester, re-indexing, and doing tours around all of the offices to locate had to be found from other resources, and I think that was just difficult to do.
Diane Wills has said in her statement, and we'll hear from her shortly, that the team had been under-resourced for a long period of time. Were you unsuccessful in your efforts to try and get more resources?
I think that a lot of work was done in my time up to the point when I left, where we were doing different scenarios where if we could increase the inquiry's internal team and reduce the external cost, what would that be? Where would we get the funding? And that debate about the different ways and different processes was underway. I think maybe if Diane has increased her funding since I left, then that work was probably done before I left. And it was clear that steps had to be taken to increase the funding. I think we had regular meetings and we had debates of budget forecasts that went to the department. We had to go to the board. The board themselves were generally very supportive when we needed money to draw down. The board, the GE, were supportive of that, but it was within the budgets that they had available.
I want to ask you about the role of Herbert Smith Freehills. You've addressed that in your statement, paragraph 25 onwards. You say that the instruction predated your role at the post office, but you say you believe it was influenced by their previous involvement in post office related litigation and also the anticipated short duration of the inquiry. I want to take those one by one. So taking the first of those, what did you believe the relevance of Herbert Smith's previous involvement to be in their instruction in the inquiry?
When I arrived, they were already in place, and as I understood, the process earlier in the year of appointing external lawyers had been influenced by the already present position within the post office regarding the legacy matters. That Herbert Smith Freehills. I believe they were involved in the compensation process, that they had already become involved in a compensation process. And from memory, I haven't gone back to look at it, but they may have been involved in the 555 process. So they had some deeper understanding of some of the issues that were going to come up in the inquiry. And as I understood it then, the decision at senior level was it made sense to utilise the information which was already available to Herbert Smith Freehills than to bring in a new firm who would then have to come up to speed with all of the issues that they had already become involved with.
Were you aware, for example, that the group litigation was going to be something that was going to be investigated by the inquiry?
When I started, no, but it was a clear issue that would obviously be of relevance to the inquiry to understand the previous trials. Although when I first started, I think the understanding was that the inquiry would not be seeking to go back into the previous litigation. So I may not then have appreciated that taking the Fraser trials from one side and the group litigation as a separate process, that they would all have been, in my head, one earlier process. And it did make sense that Herbert Smith Freehills had that prior knowledge.
In terms of the second factor, why would the length of the inquiry be relevant to Herbert Smith's instruction?
Well, as became clear, the budgetary aspects of the inquiry, in that I don't believe there was any negotiation of a budget or a fee process with Herbert Smith's before I arrived. That was already in place by the time I took up my role. So a shorter duration would not have had a significant budgetary impact on the wider post office. But the longer duration, it would have made more sense to look at other alternatives that may have been less expensive, or perhaps some kind of fee negotiation with Herbert Smith's that may have taken place.
And is this because, as you previously described, there was this fixed pot of money that wasn't expanding?
I think the post office's budget is fixed across its entire, and then the internal allocation of that budget. There had been a small budget allocated to the inquiry process, which it did continue to expand. But I think the shorter the duration, the less relevant the budgetary implications would have been. The longer the process, the more relevant budgetary negotiations would have been to any process.
Was anyone at this stage raising it with the group executive or somebody senior within the post office that they urgently needed more funding?
It was apparent, and I had conversations with Mr. Fote, who was frustrated, and his approach was very much, we need to get this done, we will have to find the money. But again, that's easy to say, we will just have to find the money. The money then has to come from somewhere. So the issue of funding was a constant theme, and whilst it may not have been openly dealt with, and it was a constant process of how much will this cost, what do we have to spend to do that. And one of the points that I think I did raise was when HSF would have said to us, we need to send 5 people to Winchester for 5 days, they would have come to Steerco and said, this is going to cost roughly this much. That would then have been approved. And I am not aware, I don't recall any instance when that expenditure was ever declined. It was always approved. But monitoring and watching that budget was essential because there was a limited budget.
You say at paragraph 26 of your statement that the approach to each disclosure request was designed by Herbert Smith Freehills. And perhaps we can look at paragraph 53, it's page 14. Thank you. You say at paragraph 53, HSF sought to identify relevant search criteria based on each Rule 9 request. Those terms were devised by and applied by HSF and were not discussed with POL. Looking back, do you think that that was an appropriate action to take?
Yes, I do. The team within Post Office would not have understood what the search criteria were set up by the external advisors who were immersed in the process. They would have set the criteria as to what the Rule 9 request was looking for. Some Rule 9 requests were very simple. You could identify a specific document. That was easy. But if it was wider requests, we relied on HSF to tell us they have received a Rule 9 request, it relates to, and they would have disclosed the Rule 9 request to myself, but they would have devised then what they needed, what they felt was the appropriate search. And they did so under the direction that it was to be as wide as possible. It wasn't to be a restrictive search.
But in terms of providing assistance to the inquiry, getting the right documents that the inquiry wanted, do you think it is appropriate for an external law firm to devise and apply search terms and not to discuss them with their client?
So when I say not, they weren't discussed. They wouldn't have sent a note to us saying, we are applying, open inverted commas, Horizon, open inverted commas, Horizon litigation, they didn't necessarily set them out. They would have, each Rule 9 request would have been brought up at a Steerco. They would have indicated where they had identified relevant areas that they needed to search, be that Post Museum, Winchester, or relativity searches. They would have indicated to us that we received, I think there were sometimes there were hundreds of thousands of hits that went to a first level review, that was reduced then to a second level review, and then the disclosures were then sent to the inquiry when the relevant material was identified.
Did they do that on every occasion?
My memory is yes that they did. That there was. I don't believe there were any requests where we were not aware of the Rule 9 or the nature of the searches. Primarily because any budget requirement to send people out to the hard copy repositories would have had to been approved.
In terms of human involvement, though, from the Post Office, in terms of somebody with experience, with knowledge of Post Office policies, procedures, it sounds from paragraph 53 of your statement that there wasn't that kind of involvement in, for example, search terms.
That it may well be. My assume there may be slightly misleading in that they did not discuss the phrasing of the search terms or how they would have framed and carried them out. The inquiry team was kind of two-layered. There was the legal side where we had the legal counsel who would have involved certain work, but there was also an operations side, and there were members on the operations side were long-standing Post Office employees, and they would have had contact with HSF, and HSF would have utilised that knowledge about questions. they could have said, have you looked at, or I remember that incident, or I remember a person who was involved in that department. So there was.
So although you've
contact.
said in your witness statement there, those terms were devised by and applied by HSF and were not discussed with Post Office Limited, your evidence is that there were people within Post Office Limited in the operational side that did have discussions with Herbert Smith Freehills.
The discussions would have been about the process, not the terms. Herbert Smith Freehills devised what searches were required, what the Rule 9 was requesting, how to conduct those searches, what they would be looking for. But they would have had access to anyone within the post office had they needed access to anyone in particular for advice on where to go looking for material. But there would be no, post office did not dictate or direct what the search terms were or what the search criteria should be.
So you've said that they had access to people at the post
Yes.
office. Did they routinely consult people in the post office with regards to requests that had been made?
There was consistent two-way conversations going on, that the contact would have been made through both Steerco and through requests for information, and any information which we devised or located. So if one of our processes located material, we would have immediately notified HSF, and if they had needed access or if they had requested any access, it would have been granted. And I do recall instances when people within the operations team did speak with HSF. I couldn't give you information as to how regular or consistent that was.
And was there a policy in place as to in what circumstances to speak to somebody at the post office?
No, there was no there's no formal policy.
Perhaps we can take an example, and that's the request for prosecution policies and investigation policies. Can we look at INQ 0000-2007, please? This is the 28th of February 2022 Rule 9 request. It's Rule 911. This was a request while you were in post. And can we look at paragraph 15 of this request? Thank you. This request says the minutes of the Audit, Risk and Compliance Subcommittee of the 11th of February 2014 refer to a report which outlined the proposed changes to the prosecutions policy and a paper to explain the most appropriate way to communicate the prosecutions policy. Please provide copies of the same and copies of all iterations of the prosecutions policy since 1999 that are in Pol's custody or control. If we move down the same request, paragraph 46, please. Sorry, it's a bit above that. Thank you. There's a reference there to the minutes of the Audit, Risk and Compliance Committee, and it says these refer to an investigations policy that was circulated. Please provide copies of the same and copies of all iterations of the investigations policy since 1999 that are in Pol's custody or control. There was a later Rule 9 asking for much the same. That's INQ 0000-2008. That was a request of the 15th of June 2022. And perhaps we can look at paragraph 18. That request asked for policies and guidelines relating to the bringing of private prosecutions against sub-postmasters and other end users. Request 22 says any guidance, training or instruction given to those responsible for conducting criminal investigations. Paragraph 26, scrolling down, similarly asks for any guidance, training or instruction given to those responsible for making charging decisions. Paragraph 30, any guidance, training or instruction given to those responsible for conducting the prosecution of sub-postmasters. And just by way of one more example, paragraph 34, any guidance, training or instruction given to those responsible for disclosure in criminal proceedings brought against sub-postmasters. These requests were made while you were in post. The inquiry's understanding was that the process that followed that was that Herbert Smith Freehills would set search terms, the repositories would be searched, and the end product would come back. And we know that a significant document, the racial profiling document, was not contained in what was ultimately produced. Is your evidence then that there was a discussion about prosecution policies with somebody in the post office between them and Herbert Smith Freehills?
I can't answer that question in that I don't have any specific memory of this individual request. My understanding would be that Herbert Smith would contact post office identifying particular search areas, so the hard copy, soft copy repositories, if there was a specific issue. In this case, looking at sort of governance policies and procedures, that would have been referred to the inquiry team. That I would believe would have been referred to the Secretariat, the Company Secretary's Department, and any responses would have been identified, passed to Herbert Smith, and then passed on.
Your evidence is that it would have happened.
That would be my belief.
And how involved in this process were you as inquiry director?
I had very little direct involvement in any of the specific processes, particularly by the time it came to June of last year. We were heavily involved in trying to expand. Even by June last year, the process had been that we would have been ending the inquiry by sort of Christmas, and then it was quite clear it wasn't going to end, and budgets were severely constrained by that point. The process, I think maybe when I came into post, it was a very small team. We expanded the team both on the legal and operational side. And just before I departed, an operations director had been appointed. The head of legal, who had been on maternity leave, was due back. And my understanding then would have been that I would have then moved into the role of overseeing, rather than being hands-on day-to-day dealing with the finance team and drafting of the processes. I would have been a much more oversight role. The majority of the requests would have been dealt with by the individual teams that were created. The process we had, phases 2 and 3 were allocated to 2 council, 3 and 4 were allocated to 2 council, 5 and 6 were that's right, isn't it? Yeah, but we're allocated then to a different set of council. And then they would have been tasked to deal with their counterpart in HSF about any requests that were relevant to their area, that they would have assisted in that process. I would not have had any day-to-day or even detailed responses or updates on specific documents that were located. I think had the racial profiling document been identified, I would have been aware of it. And I would have been made aware of it because of the gross nature of the material which had been produced.
So as inquiry director, your role was not to get involved in the nitty-gritty of the rule 9 requests. That was left to legal counsel.
Yes.
So those are qualified lawyers.
Yes.
Who you assume, or your evidence is they would have discussed those with people who worked at Pol.
To the extent that HSF would have had they would have identified teams dealing with each Rule 9 request, with each area, and they would then have liaised with the relevant person in the post office team. It wasn't dealt on a basis where the partners in HSF would deal with me. I would then allocate it down to somebody within post office who then reported back to me, and I reported back to HSF. It wasn't that relationship. The relationship between myself and HSF was much more at a higher level as to what we were doing, what our strategic approaches were, what our priorities were going to be for upcoming phases.
Is it possible that those conversations with the people involved on the operational side of the post office simply weren't taking place and that you weren't aware of that?
No, because I was aware of conversations then, because there were frustrations expressed by the operational side where they would say, I've sent material to HSF and they've asked for it again and I've already sent this. So there were definitely ongoing discussions and ongoing exchanges. And that was taking place. But the exact nature of who was speaking to who and what they were asking for and what was being produced was not reported up to me. I was aware of the frustrations both from HSF saying we've asked for certain material which hasn't arrived. I would then say, look, what are we doing? And then from our side saying, I've sent this 3 times. And then me going to HSF saying, apparently this has already been sent on 3 occasions. So there were conversations at the lawyer level, either between the lawyers and the internal lawyers or the lawyers in HSF and the operational team within Post Office.
In order to assist those who are currently working for the Post Office on their disclosure, can you tell us why you think that kind of a breakdown would happen?
I think it's just the size. Partly, I think it is the size of the team within Post Office. There was a limited number of people, and some of the operational staff had other BAU duties and responsibilities, so they weren't dedicated solely to the Post Office. And I also think partly, I'm criticising our own profession here, but I don't think lawyers sometimes understand and can explain to non-lawyers what they are asking for as clearly as maybe they should. But I also do think part of the problem can be something the size of this inquiry where one member of the Post Office is responding to one person in HSF, and there are 3 different teams in HSF doing 3 different jobs. But the Venn diagram arrangement of inquiries is certain matters do overlap. And getting repeated requests for a document you sent to person A from person B or person C, the Post Office staff get frustrated because I've already sent that, but it was to a different team for a different purpose.
So was there a lack of communication between the various Herbert Smith teams rather than a lack of communication between Herbert Smith and the Post Office?
I think there may well have been a lack of clear understanding, but again, the sheer volume of what's being dealt with, that understanding what document has come in and having a central repository of all of that information, plus how you name it. I name it board meeting 12th of January, somebody names it board meeting Re-Horizon, third person names it board meetings. They're asking for the same document, but they called it a different name because of the distinction within the Rule 9 request as to what it is you're actually looking for. So there may well be a lack of clarity in what is being requested, consistency in namings, or just an understanding within the teams. Herbert Smith asking for one thing, Post Office thinking they're asking for something else. I think that is quite likely that there were instances where that did happen.
And when you were in post, is it your view that Post Office was lacking a central individual to filter those kinds of requests? Or was it a general understaffing or something?
I think the team was generally understaffed in that there was a huge job to be done, but that there weren't enough people to do all of the tasks, which meant that you had to prioritise within the teams. And that may well have led to some requests or some understanding falling between the cracks.
Looking at that racial characteristics document, we've dealt with it with Mr. Fote, so I'm not going to deal with it in depth with you today, but you've said that you sat on a steering committee that related to Freedom of Information Act requests, and that there was liaison, in fact, between the Freedom of Information people and the inquiry people, and that I think you were that figure that sat on both committees, yes. For example. How, in your view, do you think it is that that document, having been disclosed under the Freedom of Information Act, wasn't brought to the relevant people's attention promptly?
I have no comprehension as to how that did not. That would have been after my time, so I don't know how that happened. I do recall instances when documents were brought up that were going to go on Freedom of Information requests, and we immediately ensured HSF advised the inquiry that material was going to come out because we didn't want the inquiry's first it may not have been relevant to an existing Rule 9, but it was clearly relevant to facts and issue in the inquiry, and we did not want the first knowledge to be the front page of the Daily Mail. We wanted to make sure, even if it was only a day or two's knowledge, that you would have known. So we did, on a number of occasions, identify material that had been requested under Freedom of Information requests, and we brought them to the attention of the inquiry. So I know that that did happen. I do not know how that did not happen on this occasion.
Did you, during your period, recognise any difference in, for example, the quality of the product from Freedom of Information searches vis-à-vis the quality that was produced for inquiry's disclosure?
No. I think my feeling was that the Freedom of Information was much more directed, because the requests would have been much more specific, where the inquiry's scope is much wider and the request would be a much broader brush. So what we would be looking for would be a lot wider than what a Freedom of Information request would be looking for. So it may well have been that a Freedom of Information request would divulge 14, 20 documents. We would be locating 15, 20,000 documents. So I do not understand how that one was located by Freedom of Information when it hadn't been located previously, nor how the inquiry team were not able to notify the inquiry in advance that this was coming.
In terms of your ultimate departure, can you tell us why you left the post office?
I think, from my understanding, it was quite simply budgetary, that the cost of seconding a partner from a law firm in was extensive, and therefore they had to try to manage the long-term budget of how to manage the fees and bringing somebody in to manage the team long-term. And I think possibly then again the initial view of you were brought in for a short term to deal with a certain aspect, and it has just blown up out of all proportion from what we understood.
We will shortly hear from Mrs. Wills, who's described some successes she has had in terms of increasing the budget. Why do you think it is, or do you think it is, that Mrs. Wills has had more success in increasing the budget than you did during your time in post?
I think reality has come to play. But at the end of my time, there was a much longer and much more detailed understanding that small increases of a bit here and a bit there were not going to do it, that the inquiry was. I think the inquiry's timetable itself had been much clearly set out, that we knew then we were looking at this period, this period, this period. And hopefully that the wearing down I had done during my time and the work that I had done had softened the way for a much clearer understanding that the budgets that had been discussed were simply not valid. And we had presented various scenarios of increasing the internal team, changing firms, changing the approach. A lot of that had been done setting out various avenues. And I would hope possibly even then that there was I have no idea, I'm speculating here, which is probably incorrect for me to do so, that hopefully more funding was provided from government resources to ensure that the post office could comply with its duties and responsibilities to the inquiry.
Thank you, Jason. Thank you very much. Sir, do you have any questions?
Just one, if I may. Well, it may be more than one, but it's one discrete issue. Mr. Canavan, you spoke about the role of counsel in the various teams which were set up. And I just wanted to understand what you meant by that. Were you meaning that these people were members of the independent bar in private practice, instructed by a solicitor, or were you talking about in-house employees?
So I was discussing in-house lawyers, legally qualified staff internally, not external members of the bar.
Right. Okay. Well, it was only one question. Thank you. Yes, thank you very much.
Thank you very much, sir. We're going to hear from Mrs. Wills next, but perhaps we could take a 15-minute break, so to 11:50.
Yes, by all means. Yeah, fine.
Thank you very much.
Good morning, sir. Can you see and hear me?
Yes, I can. Thank you very much.
May I call Mrs. Diane Wills, please?
Yes.
I swear by Almighty God
I swear by Almighty God
that the evidence I shall give
that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you, Mrs. Wills. As you know, my name is Jason Beer and I ask questions on behalf of the inquiry. Can you give us your full name, please?
Diane Wills.
Thank you for coming to assist us in our work and for previously providing a witness statement to the inquiry. You should have in front of you a copy of that witness statement in your name and dated the 22nd of August this year. If you turn to the last page of it, which I think is page 37, is that your signature?
It is.
Before I ask you whether it's true, can you go back to page 29, please,
Yes.
and look at paragraph 92 at the foot of the page? I think you wish to make 2 corrections to paragraph 92, is that right?
Yes, please.
Is the first of them by crossing out in the first line the words "was agreed with"
Yes.
and inserting instead the words "guide has been designed by Pole, having consulted the"? I'll read that again slowly. Guide has been designed by Pole, having consulted the.
Correct.
And then secondly, inserting the word internally at the end of that sentence after the word used,
Yes.
so that the sentence would read, a revised Rule 9 request process guide has been designed by Pole, having consulted the external advisors and is now being used internally.
Yes. Thank you.
With those corrections, are the contents of that witness statement true to the best of your knowledge and belief?
Yes, they are.
I'm going to ask you questions about a range of matters referred to in your witness statement, but not all of them. And that's because the chair of the inquiry has read your witness statement and it will be uploaded to the inquiry's website today so that everyone can see what it says. I'm going to focus on 2 principal issues. Firstly, to seek to understand more about how 3 disclosure failings occurred concerning search terms, reviewing families of documents, and the deduplication of documents. So that's a look backwards. Mm-hmm. And then secondly, to seek to understand more about what the Post Office and its advisors have done to put things right.
Okay.
Can I start, though, with your career qualifications and experience? I think you're a solicitor having qualified in October 1997, is that right?
That's correct.
You previously worked in the government legal department until in April 2012 you joined the Post Office as its legal services director in the remediation unit.
April 2022.
Did I say 12?
You did.
2022, thank you.
Correct.
And you appear to have had 2 functions from April 2022 onwards. Firstly, to seek to deliver timely and fair compensation to sub-postmasters affected by the failings of the Horizon system, and secondly, to support the Post Office's response to criminal appeals arising from the operation of the Horizon system. Is
Correct.
that right?
Yes.
With effect from the beginning of January 2023, and upon a promotion, you became the Post Office's Public Inquiry Director, is that right?
Yes, in addition to the other role.
And you tell us in your statement that you spend about 75% of your time undertaking that role and 25% of the time undertaking the existing role, is that right?
Yes, it's not a hard split. It'll depend on the nature of the issues that are arising at the time, but that's roughly right.
When you became the Public Inquiry Director, that was a role previously occupied by Fintan Canavan, from whom we've just heard, is that right?
Correct.
You tell us in your witness statement, no need to turn it up, at paragraph 31, that you are the accountable director within the Post Office for its inquiry programme.
Yes.
Can you tell us what that means in 2 respects? First, Firstly, accountable to whom? Accountable to the inquiry or accountable within the post office?
Accountable within the post office.
And what does that mean? You are the accountable director within and to the post office?
So I'm the person that is responsible for making sure that the group executive, that the board, that the inquiry steering committee are aware of all of the issues that are going on, that I'm driving the programme forward in the way I believe is needed to deliver what's required for the inquiry. And so I'm, I suppose, internally the face of the inquiry, if you like, for Post Office in terms of people know that I'll be there to lead the work.
But what does accountability involve?
It's my job to deliver, and if I was not delivering, then presumably that would be looked at in terms of performance.
And what does the inquiry programme mean?
So it's all the work that we're delivering connected with the Post Office Horizon inquiry.
If we turn up your witness statement, please, it's WITN 0994 0200, and go to page 26, please. Page 26.
Mm-hmm.
Paragraph 83. You say, I inherited a very highly motivated team who had been under-resourced for a long period of time. Yes?
Correct.
By for a long period of time, do you mean for the life of the statutory inquiry, i.e. since at least June 2021?
So I had in mind my knowledge since I joined Post Office, which was from April 2022, and not being directly involved with the inquiry team, but just based on general knowledge and understanding of the pressures that the team were facing.
So you're referring to it had been under-resourced for a long period of time, meaning since at least April 2022?
From my perspective, yes.
Because that's when you had knowledge?
Yes.
And so it had been under-resourced for at least 8 months by the time you arrived?
In my view, yes.
To your knowledge, had issues as to the under-resourcing of the inquiry team previously been brought to the attention of others within the Post Office?
So I don't know the specific details of what have been brought to the attention of others. I know just from general conversations with Mr. Canavan that there'd been concerns about whether the budget was at the right level, but I don't know more detail than that.
To your knowledge, had issues as to the under-resourcing of the inquiry team been brought to the attention of the group executive?
I don't know.
And to the board?
I don't know.
What was your understanding of the response from within the Post Office as to issues as to under-resourcing having been raised?
So as I said, I don't know that they were focused specifically on under-resourcing. My sense was that Mr. Canavan had found it difficult to enable the Post Office fully to understand the extent of the obligations required in terms of a response to the inquiry and what that would entail, and that had therefore been the difficulty in securing the right level of budget.
So he hadn't understood?
Sorry, not he. He had found it hard to get the rest of the Post Office to understand the nature of the challenge. Sorry.
Is that the explanation for why the under-resourcing had been allowed to continue?
So far as I know, yes.
When was the under-resourcing of the team first brought to the attention of the group executive by you?
So I think it would have been in either February or March, ahead of taking a paper to the board in March, at which we focused on an increase in the budget, and as part of that additional resourcing, and there would have been discussions at the group executive level prior to that. There would have also been discussions prior to that at the Inquiry Steering Committee, which itself has a number of members of the Group Executive.
Can we look, please, at paragraph 58D on page 18 of your witness statement?
Before you do that, unless I missed it, you said February or March, but didn't give a year. I'm assuming it's 23.
2023, yes, sorry. Yeah.
Right. Yeah, thanks.
You're here dealing with part of the response to the inquiry's question to explain the events that led to the 3 disclosure failings that have been identified. And at D, at the foot of the page, you're dealing with the issues of searches that have been undertaken. And you say, my understanding from discussions with colleagues is that Fintan, Canavan and some others with relevant responsibilities had an ongoing dialogue with Pol's external advisors to seek to ensure that the searches for documents and document review strategies were reasonable in all the circumstances and comprehensive, thorough and rigorous. And then this Pol wanted to achieve cost and process efficiencies if they were achievable alongside fully meeting its obligations to the inquiry and its ambition to drive improvement going forwards. So you're referring here to conversations that you had with Mr. Canavan about search terms and review of document strategies, yes?
At a very high level.
That's what I wanted to ask you about. This is expressed at a very high level. You say on the previous page, the post office at the foot of the page, Pol, the post office, wanted to achieve cost and process efficiencies if they were achievable alongside fully meeting its obligations to the inquiry. Can you explain exactly what that means? We want to fully meet our obligations to the inquiry and achieve cost and process efficiencies.
So there has never been any doubt as to Post Office's full support for delivering what's needed for the inquiry, and that underpinned everything. So the board has been very clear throughout in terms of wanting to ensure that everything possible was done to meet the disclosure obligations. But sometimes there are ways of doing things which can achieve the same outcome, but in a more cost-efficient way, and that's what that's focused on.
Can you give some examples?
So probably the biggest example I can give is that cost was part of the driver to change the decision to move. Sorry, as part of the decision to move the recognised legal representative role from Herbert Smith Freehills to Burgess Salmon and Field Fisher.
This is talking about a stage before then. This
Yes.
is long before then.
Yes.
Can you give any examples about the Post Office wanting to achieve cost efficiencies concerning disclosure?
Only at a high level in terms of examining, for example, things like how many associates would attend each of the inquiry hearings.
I'm talking about disclosure. This is in the context.
Yes, I don't have any specific examples.
What were you referring to then of Pol wanting to achieve cost and process efficiencies in the context of disclosure?
That was how it had been explained to me in terms of looking hard at how disclosure is approached and seeing whether through working with relativity, working with KPMG, there is a different way that we could achieve the same outcomes but at a less cost.
Again, other than expressing it in that very high level way, can you think of any practical examples or actual events where that was carried into effect or was described to you?
Perhaps the process followed, I understood, was followed in relation to some of the hard copy work where it was done in stages, so that, for example, in the review of the backup tapes which were discovered at a site, rather than going straight into a full process review, instead the work was started to identify the policies which led to them being designated as backup tapes. There was work done to identify indices so that there was a high level understanding of what might be on there. There was then a sampling done So it was done in stages to try and achieve some efficiencies while still being mindful of our overall obligations.
In relation to the three issues that we're concerned with, the use of search terms or the misuse of search terms, reviews of family documents, and the deduplication exercise, was the Post Office's desire to achieve cost and process efficiencies relevant to any of those?
I've never heard it described in terms of a cost efficiency. It was always about what was reasonable to do in the circumstances, which inevitably has some implications for cost.
By that answer, Mrs. Wills, do I understand you to mean that desires to save costs are relevant to the three disclosure failings that we're looking at?
No, I mean that it's an inevitable output in terms of decisions taken as to what is reasonable, and the approach taken, depending on how wide or not that approach is taken, will have different cost implications.
Okay, I'll move on. That can come down from the screen, please. One of the principal issues which the inquiry, I think you'll understand, we're investigating is, in the substance of our hearings, the non-disclosure of documents by the Post Office in civil litigation and in criminal litigation, which the Post Office, brought against sub-postmasters. Mm-hmm. And I think you will realise, is this right, that the Post Office was significantly criticised by both the High Court and the Court of Appeal for what was described as obstructive conduct in relation to disclosure.
Yes.
And against that background, we're investigating it. It's been the non-disclosure, and it's been the subject of significant criticism in the past. Would you agree that the disclosure which the Post Office gives to this inquiry must, in the circumstances, be full, accurate and timely?
Yes.
That's essentially a commitment that various senior executives in the Post Office have been committed to giving in the inquiry, is that right?
Yes.
And it's what the law requires?
Yes.
Can we look, please, at paragraph 43 of your witness statement on page 13? 43. Just explaining the abbreviations. HSF is a reference to Herbert Smith Freehills.
Yes.
The inquiry lawyers, and until recently, the inquiry recognised legal representatives
yes.
for the Post Office. And P&P are Peters and Peters. We'll come to each of those in a moment. You say Herbert Smith Freehills and Peters had a broad general authority from the Post Office as its instructed representatives to progress disclosure in conjunction with KPMG International without reverting to POL to the Post Office for specific instructions.
Yes.
You're here referring to, I think, the past, i.e. the period before you took up office on the 1st of January 2023, is that right?
That's the system I inherited on joining, and which, to an extent, has continued until more recently.
To your knowledge, was the decision taken by the Post Office to give Herbert Smith Freehills and Peters a broad general authority without reverting to the Post Office for specific instructions in relation to disclosure issues, a deliberate decision?
I don't think I can answer that. I wasn't involved in those discussions.
The consequence of the decision, would you agree that if there are issues or problems with the way that disclosure is undertaken by those external advisors, then the Post Office can say, although ultimate responsibility rests with us, Post Office, to give proper disclosure, in fact, the errors and mistakes were not made by us, they were made by others?
I don't think that was ever the intention behind it.
That's the consequence of it.
Yes.
And indeed, I think that's exactly what you do in your witness statement, isn't it?
Yes.
If we just look at paragraph 10 on page 4. You're dealing with request 1, paragraph 10, which was please explain the events which led to the 3 disclosure issues, explaining in detail all relevant decisions and communications that led to the errors and identifying those involved. You say the relevant decisions and communications took place between Pol's external advisors. The Post Office did not direct these communications or take these decisions. Consequently, the witnesses from the Post Office's external advisors will be able to provide closer accounts. And then over the page at page 12, you're dealing with request 2B. Request 2B was please set out where you consider responsibility for the errors lies. And you say at 12, as I've explained in relation to request 1, the relevant decisions and communications took place between the Post Office's external advisors. Accordingly, any responsibility primarily sits with the Post Office's external advisors. Yes?
Yes.
In relation to, that can come down, thank you. In relation to other issues, signing off proposed communications to the inquiry, signing off written, closing and oral submissions to the inquiry, signing off submissions in relation to compensation issues. You indicate in your witness statement that by contrast, you were involved very directly with those.
Yes, I or my team.
You tell us that in relation to those issues, communications with the inquiry, signing off submissions and signing off communications in relation to compensation issues, you have frequent and direct contact with Herbert Smith Freehill lawyers.
Yes.
You receive updates from them via email.
And through oral conversations.
And you say that you, in your witness statement, you attend a series of standing meetings with them.
Yes.
Why, to your knowledge, was a different, more hands-off approach taken in relation to disclosure issues?
So reference to the communications with the inquiry, I had in mind the production letters that go to the inquiry, so the Post Office has visibility at that stage of what is being produced to the inquiry. We have the earlier visibility of the Rule 9s coming in. Those discussions...
sorry to interrupt.
Sorry.
What about the bit in the middle?
That's what I was just going to come to.
Yeah.
The regular calls that we have with Herbert Smith go through the Rule 9s that are currently outstanding. There is a high-level discussion so that I'm aware of any resourcing issues, any major issues. What I didn't have, and I think my team only had a limited knowledge of, was precise details such as things like search terms and how deduplication was being applied.
And my question was why you get sight of the Rule 9 that comes in, you get sight of the production at the end that goes back to the inquiry. Why was a more hands-off approach taken in relation to the part in the middle?
So I think there's a combination of two reasons. One is that the reason we appointed the firms we did was because of their expertise, and we wanted to be able to make good use of that, and also their greater resource levels than we had. But also that there wasn't sufficient capacity within the team to have the level of engagement on these issues that I would have liked.
So it comes back to the resourcing of the internal poll inquiry function.
In part, yes.
You speak in your witness statement about a series of committees and groups within the Post Office that have responsibility for the inquiry programme. If I can deal with each of those in turn, there's something called the inquiry team, capital I, capital T, at the Post Office, made up of lawyers and project managers. Is it right that that had no responsibility for or oversight of any disclosure issues?
No, that's not correct.
There was and is an inquiry steering committee.
Yes.
is it right that that had no responsibility for or oversight of disclosure issues?
No, it did have.
Sorry?
It did have.
It did have.
Yes.
Can you tell us in relation to each of those the levels of, firstly, the inquiry team, the oversight of and responsibility for disclosure teams, disclosure issues?
So within the team, each of the lawyers had a particular responsibility for a phase of the inquiry, and any Rule 9 issues that arose in relation to that phase, they would have the day-to-day responsibility for contact with the external lawyers. They were supported in that role by a project management team and a specific person in the team who had responsibility due to their long-standing corporate memory of helping us understand who across the business we may want to engage with in order to gain corporate knowledge from subject matter experts.
If your paragraph 43 is right, that Herbert Smiths and Peters had a broad general authority in relation to disclosure without having to revert to the post office for specific instructions, what oversight and responsibility was it necessary for these inquiry lawyers within the post office's inquiry team to undertake? What were they doing about disclosure?
So my understanding is that the team's main role was in order to help HSF understand who may have the relevant data that was relevant, where that might be held, to try and find relevant custodians within the department. We didn't, for example, have any knowledge about an approach being taken on family documents. So that wasn't something that we would have had knowledge or oversight of, nor, as I say, the deduplication, other than, I guess, at a high level, that it makes sense to try and avoid providing duplicates of something, but no more than that. But the team's role was much more involved in just helping source the material.
Where are the documents? What are our repositories? Which buildings need to be looked at? That kind of thing.
Yes, but then also through discussions with those individuals to try and help build the information necessary for HSF to then determine search terms. So, for example, what project names were used, what common acronyms or abbreviations were used within a team, so that would then help HSF to make the more technical decision about precisely what search terms would be used.
I see. So narrowing it down then, the inquiry team didn't have any involvement in or knowledge of the detail of decisions taken as to the review of family documents, which is one of the areas we're looking at.
That's correct.
And didn't have any knowledge of or involvement in decisions concerning the deduplication of data sets, other than to know in general terms it's a good idea that things are deduplicated.
Correct.
The second area that we're looking at. On the third issue, search terms, I think you've just told us that the inquiry lawyers within the post office have discussion and liaison with the external advisors over the appropriate search terms to use. Is that right?
No, I think it's more that they acted as a conduit for HSF to engage directly with the business and may have been present on calls, for example, but were not themselves, so far as I'm aware, directing the nature of the precise search terms.
And can we ask the same set of questions in relation to the steering committee then? Any involvement on or responsibility for the family review issue?
They'd have had no knowledge of that.
In relation to the deduplication issue?
Again, no knowledge.
And search terms?
I wouldn't expect them to have any knowledge of that either. The knowledge for Steerco about the Rule 9s was just a broad sense of what was coming in, what was being looked at, what we were finding, any challenges in that, timescales, whether it had impact on resources. It was more strategic involvement than day-to-day.
And same answers in relation to the group executive?
Yes.
And still further up the tree, same answers in relation to the Post Office Board itself?
Yes, that's correct.
Would you say that through the inquiry team within the Post Office, the Post Office, exercised intrusive supervision and intrusive oversight of the disclosure process that was being carried out in its name?
I don't think I could categorise it as that, no.
Can we turn to paragraph 13 of your witness statement, please? Which is on page 5. We've dealt with paragraph 12, responsibility primarily resting with external advisors. And you say in 13, however, that doesn't change the fact that the Post Office remains responsible for its own disclosure to the inquiry. You hope it's made clear from the rest of the statement that the Post Office takes that responsibility extremely seriously. So you rightly say that the Post Office remains responsible for its disclosure to the inquiry, and you say that it takes the responsibility extremely seriously. Why, given those two things, did the Post Office not exercise intrusive supervision or oversight of the disclosure that we're being given or not being given?
I think until recently, until the issues have come to light, it wasn't understood that there were issues of the scale that we've now come to realise. And so I don't think it was understood that there was a concern about the approach being taken that meant more intrusive supervision was required.
But Mrs. Wills, in a case concerning significant non-disclosure to criminal courts in the past, which has been extensively and deeply criticised by both the High Court and the Court of Appeal, wouldn't the disclosure being given to this inquiry naturally require intrusive supervision and oversight, whether or not you knew there was a problem?
Yes, I can see that, but I believe Post Office considered it was meeting its obligations by having appointed the firms it had.
And one of the issues we're investigating is delegation of functions to a supposedly expert contractor, Fujitsu, and whether washing one's hands of a problem and saying it's down to our external contractor was an appropriate way to go. Are there shades of that on this occasion in relation to disclosure?
It's not how I'd see it. The team had regular engagement with Herbert Smiths, had regular engagement with KPMG and Peters & Peters, and I think the belief was that we had sufficient knowledge of how disclosure was being conducted.
Can we turn to page 10 of your witness statement, please? You say in paragraph 34C, my focus has been in three main areas, and then at C, you say ensuring that the ISC, that's the Inquiry Steering Committee, and the Post Office's Group Executive and Board are appropriately aware of and consulted on risk issues relating to the inquiry as they are identified. This is obviously essential to thorough risk governance. In order for thorough risk governance to take place, don't you have to know what the risks are in the first place?
Yes.
Does that not necessarily involve conversations with and written communications with your advisors that seek to identify what the risks are?
I believe Post Office thought it understood the nature of the risks, and it's only really since June, with all the extensive work that's been undertaken, that we've identified additional matters.
So if it's the case that the external advisors have adopted a disclosure strategy that's mainly focused on keyword searches, the conversation is, we've adopted a disclosure strategy that's mainly focused on keyword searches. These are the risks that involves. Or we've decided to leave it to the discretion of an individual low-level reviewer to decide on a case-by-case basis whether to look at a family of documents. That carries the following risks. Those things need to be identified, don't they? They need to be bubbled up to the surface in order that risk governance can take place, don't they?
Yes, they do.
By the time of your arrival, that hadn't happened, had it?
I can't speak about what had happened before my arrival.
Can we turn to paragraph 40 on page 12, please? In the middle of the paragraph here, and you're talking about the current day, you say, I attend twice weekly standing meetings with the 3 partners responsible within Herbert Smith Freehills for leading the inquiry work, as well as regular detailed strategy meetings. These meetings are used to discuss priority issues and risks as they are identified, and to establish matters that require escalation.
Yes.
Between January and the discovery of problems with disclosure in late May and early June 2023, were the risks associated with the way in which Herbert Smith Freehills, Peters and Peters and KPMG were approaching disclosure ever discussed in the meetings you refer to here?
Yes.
And what risks were identified?
So there was frequent discussions about the ongoing work in relation to hard copy data and some of the repositories that have been found there, including electronic data. I was also aware around April time of concerns that as to whether or not the right repositories had been searched in relation to one particular Rule 9. I can't immediately think of other specific risks.
So again, that's focused on places and vaults of material.
Yes.
Rather than the 3 issues that we're looking at. Had any discussion occurred between January and late May, early June 2023 about any risks being associated with the way in which those 3 advisors were approaching disclosure concerning the 3 risks that have now been identified?
I had been made aware of some concerns as to resourcing challenges within KPMG that could have impacted on disclosure, and we've been addressing those, but I'd not been made aware of any, as far as I can recall, certainly nothing about family documents or deduplication. I don't recall being made aware of any specific concerns about search terms.
What were the resourcing concerns within KPMG that were drawn to your attention between January and end May 2023?
I think in about February or March, concerns were reported through to my Operations and Strategy Director that the time being taken by KPMG to respond to certain requests was slowing things down and impacting the ability of HSF to carry out the reviews that were needed. So Post Office worked with KPMG to develop 2 solutions. One, an offshoring resource centre in India that KPMG could then call on to boost their resources where required, and also a system in place to ensure that it had the capacity to do weekend working and late evenings where particular rule lines required it.
At that time, were KPMG not working in the evenings or at weekends?
I don't know the detail, I'm afraid, but I assumed there was a need for more, given the conversations that we had.
And was the offshoring to India solution taken up?
Yes.
What is the nature of the offshoring to India solution? What is done?
So I don't know the technical detail of the work they do, but I know there is an additional team based out there, I think in the region of around 12 people, who supplement the work of the London-based office, dealing with some of the more simple tasks, as I understand it.
Do you know what that is?
I don't, I'm afraid.
Have you any clue as to even the realm within which the offshore India team is operating?
Sorry, could you clarify your
yes,
question?
what are they doing? Deduplication? Are they doing data reconciliation?
I'm sorry, I don't know. Hopefully Mr. Tombleson will be able to answer that this afternoon.
Can we turn forward, please, to page 30 of your witness statement? And paragraph 93. And you're again talking in the present here. You say the inquiry steering committee, which I chair, meets at least fortnightly, and disclosure, both remediation and going forward, is part of the regular agenda. When you joined, is it right that disclosure was not part of the regular agenda of the ISC?
It wasn't a standing agenda item in the way it's become since June, but certainly any issues that were arising, such as in relation to hard copy data, were brought to the attention of Steerco as was needed.
Do you know why disclosure was not part of the standing agenda before the disclosure failures which have been revealed were revealed?
So the papers that go to Steerco comprise a number of components. There are papers which are for noting on issues we just want to make Steerco aware of. There are decision papers, and then there's a full suite of management information, which includes, for example, progress on Rule 9s, and also has management information relating to progress generally in relation to disclosure. So the papers were always there, they just may not have always been discussed.
And why was that?
If there was a particular issue that we needed a view on, we would have discussed it. If members of Steerco had any questions in relation to the papers we were providing, we would have discussed it. Otherwise, it was there for their general awareness.
I mean, standing back, the disclosure given by the Post Office to this inquiry is one of the main features of its engagement with the inquiry. It's not necessarily the advocacy that the Post Office does within the inquiry. The provision of witness statements and disclosure are the main touch points between the Post Office and the inquiry. And the impression that I'm getting from reading your witness statement, please correct me if you're wrong, is that there was before your arrival, and to some extent for a period after your arrival, disclosure, although it was spoken about in terms of being an important and high priority, a rather laissez-faire attitude was taken to it in terms of that's the responsibility of the external advisors and not us. Is that unfair?
I think it is unfair. I think I categorise it as that part of our relationship with the external advisors is that we would expect them to be bringing to our attention any issues which we needed to address or be concerned about. And then we'd have the regular updates, and in between those two things, we felt we were getting sufficient oversight of information.
So reliant on the external advisors to identify problems with their own work?
Problems with their own work, but also challenges they may have been facing within Post Office, for example, getting access to right repositories, etc.
I mean, putting it frankly, isn't this the case? Isn't this the inquiry where the internal Post Office team should be all over disclosure from the top and the bottom of it, day in, day out?
Yes, in an ideal world, and I think that's what I'm now driving towards. And it's a wholesale change since June.
And I appreciate that you're, to some extent, speaking of the past here, and that places you in some difficulty. But shouldn't that have been obvious from the start? Why did it take these 3 disclosure failings to move disclosure up the agenda?
So I think it's been a trajectory of understanding on the part of the Post Office in the way Mr. Canavan described, in terms of Post Office not having that initial understanding of what's required by an inquiry, and that gradually increasing, and the scale of the issues getting broader, the scale of the challenges being faced getting bigger, and it coming right up the agenda.
Can I turn then to the 3 issues identified by the Chair in his previous decision and directions on disclosure failings by the Post Office? Firstly, the use of search terms. Secondly, decisions made to review or not to review families of documents. And thirdly, deduplication exercises carried out on behalf of the Post Office. So firstly, the approach taken to the use of search terms and the searching strategy. Can we begin by looking at paragraph 58A on page 17 of your witness statement?
Yes.
You tell us, my understanding based on discussions with colleagues and information provided by the Post Office's external advisors is that the Post Office employees and contractors were not involved in data strategy discussions at a detailed level. In general, the Post Office was updated about some of its external advisors' search parameters and review strategy choices as part of business as usual client reporting. My understanding is that the Post Office's external advisors' decisions about search parameters and review strategies largely developed iteratively in response to feedback and knowledge obtained through document searches and document review. Post Office employees and contractors were not substantively involved in discussions about those detailed matters because the Post Office's external advisors had the specialist experience and resource, and because they were conducting the disclosure exercise on a day-to-day basis, had the detailed knowledge required to make those choices, whereas the Post Office did not. And so you're essentially saying three things there. Firstly, it was the external advisors that made the decisions about search parameters and review strategies, yes?
Yes.
Secondly, Post Office employees were not involved in the substance of such decisions, although they were sometimes told about them.
So, as I said earlier, they may have been involved in discussions to help the external advisors understand what search terms they should apply in terms of, for example, a project name. But I don't believe they were involved in very specific search terms to be used generally in relation to a Rule 9.
And thirdly, they weren't so involved at any detailed level because it was believed that the external advisors had the requisite knowledge and the Post Office didn't.
Yes.
Can we look at an example? It's in fact the search terms which turned up what is now known as Appendix 3.
Yes.
Can we look, please, at poll 0011 4170 DS, page 82. You'll see this is the first interim disclosure statement dated 27th of May 2022, and if we can go to page 82 and look at the bottom, please. And so we'll see in the third column across, under A, a copy of the relevant request. Here, copy of Post Office investigations policy, together with all iterations of the same since 1999 that are within the Post Office's custody and control. That was the inquiry's request, yes? And then we'll see the explanation of what is given against A in the far right-hand column. The Post Office produced approximately 260 documents in response to the inquiry's request for all iterations of the investigations policy from 1999 to date. In order to identify these materials, the following search was conducted over all of the materials which the Post Office had at that time harvested from the Postal Museum and Oasis archives over the page. And if you look in the right-hand column, search terms, policy, and investigate or prosecute or whistle. So they were the search terms that were used.
Yes.
Yes? So the search term that the advisor, the lawyer, used here was the word policy, where it appeared in the same document as investigate or prosecute or whistle. Yes?
My understanding based on that document, yes.
Yes. And so what has been done is the truncated words of investigate, investigation, investigator, or prosecution, or prosecutor, or prosecuting have been used. You can see the little hash after the T. Yes?
Yes.
And so these search terms wouldn't catch documents if they were called protocols.
If these were the only search terms used, that's correct.
They wouldn't catch documents if they were called guides.
No.
Or if they were called guidance.
No, I think that's correct. What I don't know is whether other searches were being done to try and identify those materials.
Not so far as we've been told. Isn't that the kind of thing that a post office employee might be able to tell the lawyer? But hold on, I've got some knowledge of these things, and in the post office, we didn't call things policies, or we did call things policies, but there was this other level of document as well. It was called a guidance. You need to use the truncated term guide or guidance.
So that's my understanding of the role of our subject matter experts within the business, is that that's how we would use them. I'm not familiar with any particular discussions that were conducted in relation to this or other searches.
What you told us earlier in your statement was that there wasn't any detailed liaison over search terms involving post office employees, such subject matter experts.
I think what I tried to explain was that the role of the subject matter expert would be, as you've said, to sort of say, did we use policy, did we use guidance? What I wouldn't expect them to do is advise, that means you therefore need to use this truncated word in order to find all the documents. It's that balance.
And to your knowledge, did that first part of the conversation ever occur? I know you won't know in relation to this, but at a general level, we've got this Rule 9 in. We need to get the subject matter expert into the room. Let's sit down with them for a day and talk through it, work out which search terms they would suggest are used, because after all, they've spent their life dealing with investigations policy or prosecution policy.
Yes.
Did that occur?
So I've never been directly involved in any of those discussions, but that's certainly I've always understood those to happen. What I have sought to do is make that more systematic, so that we now have a list of identified subject matter experts across the business who we believe will be able to help us. And whenever any new request for information now comes in, one of the very first things we do, an initial strategy meeting, is to discuss with them, to have those kind of discussions. So I understand it was happening, but I don't know whether it happened in every single case.
Well, hold on. You told us back in paragraph 58A of your witness statement that although the Post Office was updated about some of the search parameters and review strategies, the Post Office was not substantively involved in discussions about any detailed matters concerning search parameters and review strategies, because the lawyers, the expert advisors, had the specialist knowledge and Post Office did not. Because I think you've just said that, in fact, on occasion, Post Office people did have such specialist knowledge and they were brought into the conversations.
So I'm sorry if I'm not explaining this clearly. I am seeing this in two levels. One, that there's a general discussion with the people whose role it was to know about these sorts of documents, so that conversations could be had to enable the lawyers to understand what sort of things they should look for. What I wouldn't expect them to have been involved in is the actual construct of the search terms on the back of that, and it's that different layer that I was trying to get across.
Okay, so how frequently were they involved in discussions over the appropriate search terms to use? In relation to...
So the second layer that I'm...
No, the first
layer.
Yeah.
So I couldn't quantify it because I think it would depend entirely on the nature of the Rule 9, the extent to which there were people within Post Office that had the right corporate knowledge. The earlier in time things go back, obviously, the harder that was. I'd expect it to be much more frequent going forward as the date range moves forward.
So if we wanted to, we could drill down into each Rule 9 if we asked for disclosure to see the extent to which a subject matter was brought into the room and did help to the lawyers to develop search terms.
I would assume those records would exist, yes.
Why is it increased in frequency more recently?
Because the nature of the work of the, as we move forward in time, there's more likely to be people within Post Office that do have that corporate knowledge, and so able to bring more assistance.
Why, as we move forward in time, is
Just
there
because-
more likely to be people with corporate knowledge?
Just because other people might have left in some of the very earlier stages.
Oh, I see. So you're not saying that the longer the inquiry goes on, the more knowledge will be obtained?
No, sorry, no.
Understood. Can we look, please, at paragraph 21 on page 38 of your witness statement? We should just look at the foot of page 20 first, please, to get some context. Page 63 at the foot. You're here dealing with Rule 9, Request 11 and 14. These are the relevant requests, certainly the second of them, that ought to have, it's accepted, I think, turned up, not only Appendix 3, but Appendix 6. And you say, I understand from Peters and Peters and HSF that both firms were involved in deciding the search terms in relation to Request 11 and 14, with HSF having primary responsibility in respect of some of the questions, and Peters and Peters having primary responsibility in respect of others. The search terms used to seek to identify the Post Office's policies and procedures relating to prosecutions and criminal investigations, i.e. broadly those relevant to questions 15 and 46 of Rule 9.11 and question 18 of Rule 9, Request 14, were significantly informed by work Peters and Peters had done in connection with the post-conviction disclosure exercise, utilising their pre-existing knowledge and understanding of Post Office's documents. I understand there was also liaison between HSF and Peters in relation to appropriate search terms, particularly in relation to questions 15 and 46 of Rule 9, Request 11. What you don't say there is that there was any involvement by anyone from the Post Office.
I'm not aware of whether there was.
Did you ask?
I think I must have done. I don't know why I haven't mentioned it here. I'm sorry.
And does the absence of any positive return in this paragraph suggest that there was no involvement by the Post Office in the development of search terms concerning these parts of Rule 9, Requests 11 and 14?
So I know there were discussions with the security team, but I don't know whether that was done as part of the remediation process or whether it was done originally. I'm afraid I'm not entirely sure.
You say here that the search terms used were significantly informed by the work Peters and Peters had done with the post-conviction disclosure exercise. The search terms that were used were truncating the word investigation to the word investigate. How was the work that they had done in connection with the post-conviction disclosure exercise utilised in order to truncate the word investigation to the word investigate?
I don't know, I'm sorry.
How do you've said here that it's because of their past knowledge of the post-conviction disclosure exercise that they developed these search terms. And what we've seen is that for 2 words, they cut the end off. What's the relationship between this past specialist expertise and cutting the end off a word?
So I don't know there's a relationship with cutting the end off the word. I imagine it's with identifying the word initially. So the word investigation, not that it would appear to require much specialist knowledge.
For investigations
okay,
policy.
Yeah, I can't answer that, I'm sorry.
What did you mean by this, that the search terms used to seek to identify policies and procedures relating to prosecutions and investigations were informed by the work they'd already done? Because we've seen the search terms and all they did was cut the end off a couple of words.
Probably a more accurate description is that the work generally that Peters and Peters had done for the post-conviction disclosure exercise had been utilised in order to find requisite documents, build repositories, and their knowledge of that work was then used in terms of helping to develop search terms generally, not necessarily in relation to this specific aspect.
I understand. And can we lastly, on this part of the issue, look at paragraph 62 on page 20, so the previous page. Thank you. You say search terms were selected by HSF or Peters and Peters through collaboration between the 2 firms and implemented by KPMG. And then you make this slightly more positive assertion: the Post Office was not involved in substantive discussions about what search terms should be used. So that does sound like you asked the question in relation to these Rule 9 requests and were given the answer, that the Post Office wasn't involved in discussions about what search terms should be used.
Possibly it may be back to the same point I was trying to make earlier about the higher level of involvement of Post Office in understanding the nature of work to enable those search terms to then be devised by the lawyers. And I was meaning that there was not involvement in the sort of end product as to precisely what search terms should then be used.
So the cutting of the end off of words?
Yes.
You say in brackets at the end there, I've been informed by colleagues that some lists of search terms were shared with Pol. What was the purpose of sharing some lists of search terms with the Post Office? Why were they being shared?
I assume so that there was a record for Post Office so that it could see what had been done.
Was there ever any request from the external advisors? These are the search terms that we've settled on. Have you any comments to make?
I'm not aware of any.
Here you're saying that the Post Office was not involved in substantive discussions about search terms. Do you accept or acknowledge that now to have been a mistake?
So I think there will always be a certain level of expertise that we'd expect to rely on our external advisors for in terms of the best way to construct search terms to deliver the best results from relativity. Should we be as involved as we can be in terms of identifying in the first place what search terms to use? Absolutely.
Do you know why it didn't happen?
No.
In paragraph 64 over the page, please. You say, I understand from the Post Office external advisors that Appendix 6, that's the identification codes document, was not returned by any of those search terms, or indeed any other search terms that have been implemented. from information I've been provided with by the Post Office's external advisors as part of the remediation process, I understand that this is because the document is really quite exceptional and doesn't contain any of the words that would normally be seen in a policy or procedural guidance. Is that the explanation that has been sort of settled and accepted between the Post Office and its external advisors? Because the identification codes documents doesn't contain words that you would expect to see in a policy or procedural guidance, we couldn't reasonably expect to have found it.
I think it's one part of the explanation.
What about the other part of the explanation?
So I think that then takes you to the need to discuss with subject matter experts, and then also in relation to the approach to family documents.
And so a discussion with a subject matter expert might have revealed, for example, well, hold on, we had these compliance standards that we had to achieve in the security team, and they were sent out regularly by email in a series of attachments in a zip file. Some of them concerned file completion. Some of them concerned the need to insert an identification code. You need to look for the zip file, which has got that suite of documents in it. That's the kind of thing that might have been discovered if you bring people whose day job it was for decades to conduct investigations and prosecutions into the room, isn't it?
Yes. The reason I'm hesitating is because that document was on relativity, so it had been harvested. I don't know the circumstances which had led to that document being harvested, and so I don't know if it was the failure to discuss with with subject matter experts which led to it particularly being identified.
Well, to that extent, this explanation here misses the point, doesn't it? Because as you rightly said, Appendix 6 was part of a suite of policy and procedure documents. Yes. One part of the suite was responsive to a search term, but nobody looked, it seems, at the other documents in the suite of which the responsive document was a part.
Yes, but I was trying to answer the question in relation to search terms.
But overall, would you accept that the real lesson to be taken from this episode concerns the need to look at other documents within a suite of or a family of documents of which a responsive document is a part? Yes, and I understand that there was no hard and fast rule that families would never be looked at. It was always decisions were taken as to the circumstances in which it would be appropriate. I'd expect that to be looked at hard and even harder now as to the right approach. So you would expect what to have been looked at hard? In relation to whether or not the full suite of documents needed to be reviewed. We're going to come to that in just a moment, but just finishing off search terms, if we can lastly look at paragraph 114 of your witness statement, which is on page 36. You're here summarising your position on where responsibility lays for the non-disclosure by reason of search terms. And at paragraph 114, you say, I do not have the knowledge or technical expertise to express a view on whether they were suitable or whether anyone designing the searches who did not already know that Appendix 6 existed and the nature of its content reasonably could have selected additional search terms that would have returned that document. So you're essentially making the same point that we saw earlier in your paragraph 64, but in a less direct way. Are you essentially asking a form of rhetorical question there with a pregnant suggestion that no one could reasonably have selected a search term to pick Appendix 6 up without knowing the existence of the document beforehand? I'm saying I don't know whether search terms could have been devised.
to do that. But the information I've seen is that those, or the information I've been provided with, is that there's nothing within the face of that document that would immediately lend itself to being identified by the search terms that would have normally been used in such circumstances.
And is that how the Post Office thinks that search terms work? That it's all about the design of the search terms? If search terms are reasonably selected and settled upon, they'll likely turn up the relevant documents.
Yes, except that search terms is not the only device that's used to try and identify the right documents.
What if I suggest to you that search terms are merely part or the start of an exploration for relevant materials, in which search terms may lead a reviewer to a relevant document? The document itself needs to be read to see whether it's associated with other documents which may also be relevant but are non-responsive to the search terms.
Yes, I think you've described it more eloquently than I had, but I think it was the same point I just made. It's not the start and finish.
So it's a train of inquiry starting with search terms but not ending with search terms.
Well, the train of inquiry starts with identifying the irrelevant custodians, where the data may be held, etc., before the search terms can be applied.
But essentially, I think you're agreeing with me that the use of search terms can only be part of a disclosure strategy. They will lead you on a train of inquiry, and the train must be followed.
Yes.
Can we turn then to the Post Office's approach to reviewing family documents? And can we turn to page 22 of your witness statement? And can we read together paragraphs 67 to 70? You say, I've been informed by HSF and Peters that across the inquiry's disclosure request, various approaches have been taken to reviewing family documents. Depending on the nature of the relevant disclosure request and what HSF or Peters consider to be reasonable in the circumstances, in some instances, HSF or Peters reviewed whole families of documents and assessed whether each or all should be produced to the inquiry. However, in other cases, HSF or Peters only reviewed the documents that were returned by the search terms. The Post Office was not involved in the operational decisions about review approaches for family documents. These were taken under HSF and Peters general authority to progress disclosure.
Yes.
So again, just to summarise all the threads together, different approaches were taken by your advisors, that can come down, thank you, to different requests as to whether they reviewed a family or documents or not, or whether they just looked at the document that was a hit, was responsive to the search term.
Yes.
The choice was made by your advisors according to what was considered by them to be reasonable.
Yes.
The Post Office was not involved at all. Such decisions were taken under a general authority given to the lawyers.
Yes.
And so until this whole issue blew up, neither you nor, to your knowledge, anyone else in the Post Office knew what was going on in this regard.
Correct.
Is your understanding that this approach adopted by the lawyers was done on a Rule 9 by Rule 9 basis, i.e., for this Rule 9 we are going to review families, but for this Rule 9 we're not going to review families, which is how your witness statement reads?
I'm not sure I would see it as being done just at the level of the Rule 9. I think it would depend on the nature of the investigations in relation to each Rule 9. So you would start your investigations as we've just discussed, and depending on where that took you, might lead to approach. So rather than getting the Rule 9 at the start and saying we just won't look at family documents, I don't think there was ever any question of that.
And so there might be different approaches to reviewing families within a Rule 9?
Yes.
So for this bit, questions 1 to 20, we will review families, but for questions 21 to 40, we won't.
I'm not sure it's as black or white as that, even at that level either. I think it would depend on the nature of the investigations that were ongoing and the way responsive documents were being identified, and at that level, decisions would then be taken. But I'm sorry, I'm not familiar with the detail.
Can we just look at paragraph 115 of your witness statement on page 36? Again, this is answering the who's responsible question, and you're dealing in this part of the witness statement with family documents. You say, as set out above in response to request 1, HSF did not require or instruct its reviewers to review family documents, although reviewers had the functionality to review family documents and so could do so where they considered it would assist them. To the extent that documents were not identified and produced to the inquiry because of that decision, primary responsibility logically sits with Herbert Smith Freehills. This reads slightly differently, that your understanding is there was no general instruction to review family documents, but there was a function available to a reviewer, and the individual reviewer could decide to review the family or not. Is that your understanding of what went on?
So I think my understanding is that the individual reviewer had the capability, something to do with the reviewing pane and how it might have been shown.
So a panel on the screen.
A panel on the screen, but there would have been a prior discussion as to whether or not, as a sort of starting point, the family documents should be looked at for that particular aspect, which was presumably based on discussions internally on what was being seen and advice from more senior colleagues as to whether that was an appropriate course of action.
So it goes a bit beyond what's mentioned in paragraph 115 here, which reads as if it was up to the individual reviewer to decide.
I think that's probably unfair. Yes, I think there would have been discussions going on, but ultimately the documents were there and could have been looked at if the course of inquiry had suggested to that individual reviewer that they should be looked at.
To your knowledge, were there any standing instructions about when and in what circumstances family documents were or were not to be looked at by a reviewer?
I'm not aware of any.
Would you agree that such standing instructions would engender consistency across the disclosure exercise?
Yes, provided they also allowed for discretion where that was needed in relation to a particular request.
They would allow somebody looking back after the event to see the rationale recorded for when families were to be reviewed and when they were not.
Which seems to me a different point as to, I mean, there's a difference between a general guidance and then someone recording the rationale. And I'd see those as two distinct steps.
Yes. Sticking with the guidance then, you're right to pick me up on it. Instructions to reviewers that say these are the benefits of looking at families of documents. You shouldn't just think that because you're looking at a HIT, a responsive search term document, that's the end of the exercise.
Yes.
You should consider, by reading the document in detail to see whether it refers in its the body of the document to other documents. You should check to see whether it's an attachment to an email and go back to the parent email. You should see whether it is part of a file, a zip file, for example, and see whether any of the other documents are relevant to the Rule 9 that you're considering. Was there anything of that nature?
I'm not aware.
Is there now?
Again, I'm not aware of any.
Can we go back to paragraph 68, please? Which is on page 22. You say, depending on the nature of the relevant disclosure request and what Herbert Smith Freehills or Peterson Peters considered to be reasonable, in some instances, they reviewed whole families. Yes?
That's the information I've been provided with, yes.
So whether families were or were not looked at was all down to what the lawyers considered reasonable in the circumstances.
Yes.
What informed the issue of reasonableness?
I don't know what they considered.
Was it the number of documents that you might have to look at if you decided to have to look at the parent email, the costs of doing it, the time it might take?
Yes, all of which are normal considerations in any disclosure exercise, to consider the range of documents to be considered in the time available that's going to produce the most relevant documents.
But what were they told, to your knowledge?
By post office?
You've, as part of the remediation exercise, I think taken a look backwards to see what was going on. What was going on in relation to family documents? You've explained it in general terms here in paragraph 68. It all depended on what the lawyers considered to be reasonable. I'm asking for some more detail on that, please.
I'm sorry, I don't have any more detail.
So if we took appendices 3 and 6 as examples, appendix 3 was responsive to a search term presumably because it had the word policy in it.
Mm-hmm.
And investigation and prosecution in it. That appendix 3, was part of a family of documents, in fact many families of documents,
Yes.
across the archive. It was often sent, as I've said, as a zip file, as part of a series of appendices. So despite that document being part of a zip file or within a suite of other policy documents, and the whole set of appendices constituting the procedure which investigators were to apply, because a decision had been made not to look at families in this instance, a reviewer would simply not look at those other documents. Is that right?
That's my understanding.
I've got a hit. It's got the word policy and investigate and prosecute in it. That's the end of the matter. I don't see where this document came from and whether it was part of or what's in the rest of the family. I just move on to the next document.
I just don't feel able to comment further on that, I'm afraid.
Can we turn to paragraph 115 of your witness statement, please? You deal with, we've looked at 115. In terms of remediation, you tell us, I think, that a decision has been now taken to review all family documents. Is that right?
That was done in relation to, as part of the remediation exercise, to everything that had been disclosed up till now, yes.
Why was the decision taken to review all family documents if previously it was thought that it was unreasonable to have to do so?
Such was the level of concern that I think we just felt we couldn't take the risk that something else might have been missed, and so wanted to go back and make absolutely certain as to whether there was anything else relevant.
Can I turn to deduplication, please, and go to pages 24 and 25 of your witness statement? And if we can read 78 at the bottom. Just by way of explanation, at 78 you say there are two relevant levels at which deduplication can be applied. A, family level deduplication. Duplication is analysed as between complete families of documents, excluding duplicate families, and over the page, ensuring only one copy of a family survives computer processing to be manually reviewed or produced. And then secondly, at B, item level deduplication. Only one copy of a document survives, computer processing to be manually reviewed or produced, even if it appears in different family contexts. Just stopping there so that we understand it in a simple example. If I've got one email with 5 attachments to it, and I've got another email which is in exactly the same terms with the same 5 attachments to it, family level deduplication will deduplicate that.
Yes.
If I have got one email with 5 attachments to it and another email with 7 attachments to it, one of which is the same attachment as one of the attachments to the first email, item level deduplication will deduplicate the second family as well.
If both emails were exactly the same, yes.
Yes. So if both attachments were exactly the same.
Yes.
Thank you. You say, I now understand that item level deduplication is rarely used in e-disclosure because it can have significant, unpredictable, and potentially undesirable impacts on document review. Who told you this?
I believe it came out through discussions with Herbert Smith Freehills.
Why might item level deduplication have significant consequences and therefore is rarely used?
Because it could result in family documents not being available for a reviewer to see. So that reviewing pane we spoke about earlier, they wouldn't appear there.
So it hides from the reviewer's view not only the single document, which is the duplicate of the document he or she is looking at, but it hides from the reviewer's view the other documents within the family.
That's my understanding, yes.
Why might it have unpredictable consequences?
Well, it would depend on the nature of the document as to precisely what was lost, and you wouldn't know that in advance.
Why might there be undesirable consequences of this type of item level deduplication?
Because it removes the ability of the reviewer to see the relevant documents.
Is it your understanding that the approach that was in fact taken, the item level deduplication on occasions, meant that a reviewer would not see the other documents in the family, but also that the other documents in the family were excluded from other keyword searches being undertaken as part of the disclosure exercise?
Yes, I believe that's correct.
So this non-standard approach, which is rarely used and which has a series of significant, undesirable and unpredictable consequences, was used, but all without the Post Office's knowledge?
Yes.
Aside from who, as between Herbert Smith Freehill and Peters on the one hand, and KPMG on the other, was responsible for that decision, do you know why, in this inquiry, which is self-investigating non-disclosure, and indeed in the very Rule 9 we're looking at, was searching for documents about the Post Office's policy of giving or withholding documents in investigations and proceedings, this non-standard, rarely used approach was in fact used?
No.
Presumably when it was discovered, it caused more than a minor ruffling of feathers.
Yes.
Do you now know who was responsible for it?
No. It appears to be either a miscommunication by Herbert Smith Freehills or a misunderstanding by KPMG. I think both appear to have had different understandings of what was being instructed or what was being asked of them. And I haven't to date been able to understand it beyond that.
Can we look at paragraph 80, which is further down the page, please? You say, I understand that instructions to deduplicate were given to KPMG by Herbert Smith Freehills and Peters and were implemented by KPMG. I understand from Herbert Smith Freehills and Peters that they did not intend item-level deduplication to be applied in connection with the document searches associated with responding to Rule 9 Requests 11 and 14 or at all. My current understanding is that item-level deduplication was applied as a consequence of either a miscommunication by Herbert Smith Freehills or Peters, who've told me they didn't intend it to be applied, or a misunderstanding by KPMG, who've explained that they understood that their instructions were to apply item-level deduplication. So the lawyers say they didn't intend and didn't instruct item-level deduplication to be used in any Rule 9 searches. Yes?
I'm just pausing as to whether it's in any. There may have been some in which it was appropriate, I don't know, but my understanding is it wasn't instructed in relation to these Rule 9s.
It was the addition of the words or at all in the fifth line that led me to ask that question, because your witness statement speaks of essentially all Rule 9 requests, not just 11 and 14.
In which case that would be my understanding, yeah.
So the lawyers say they didn't intend item-level deduplication to be used in any Rule 9 request, and KPMG say they understood their instructions to be to apply item-level deduplication.
Yes, that's what I've been told.
Isn't this kind of unattractive squabble between highly paid city advisors why it is essential for the client itself to be involved to a sufficient degree to ensure an understanding of what's being done in its name?
Yes, though whether Post Office being actively involved in discussions would have enabled us to understand that a misunderstanding had occurred, I don't know.
But by subcontracting the disclosure issue out, you run exactly the kind of risk that has played out in this case, don't you? And by you, I mean the Post Office.
Yes.
Can I turn then to remediation? And by remediation, I mean correcting past mistakes and ensuring that other similar mistakes do not happen again. In relation to the family issue, review of family documents issue, as we've established already, the remediation in relation to family documents is essentially complete because, as you've explained, a decision has now been taken to review all family documents.
A decision was taken to review all of family documents that had previously been produced. So going forward, I think it will still be taken on a case-by-case basis.
That's what I was about to ask you. Is it in relation to all new Rule 9 requests that family documents will be reviewed, or is it in relation to past Rule 9s? And if past Rule 9s, which and why?
So the decision was taken to remediate in relation to all previous ones out of abundance of caution because of the level of concern. In terms of, as we move forward, there will be much closer analysis as to how those decisions are taken as to when to review family documents. But my understanding is that the way it could multiply the amount of documents that need to be reviewed, it still needs to be looked at on an individual case-by-case basis as to whether or not that's the appropriate outcome.
And again, as we sit here today, has any guidance been developed to tell the reviewers when to look at a family and when not to look at a family?
I'm not aware of any specific guidance.
So in relation to Rule 9s that the inquiry is presently serving, there doesn't presently exist any guidance to reviewers about when they should look at a family of documents and when they shouldn't?
So I'm not saying it doesn't exist. I'm saying I'm not personally aware. My team are certainly much more actively involved in discussions in relation to current requests from the inquiry. I'm sorry, I don't know whether they may have seen any.
In relation to the search terms issue, can you explain briefly what has been done in relation to remediation of that problem?
So in relation to the specific issue that was identified, which I understand was in relation to the, I think the failure to shorten the word guidance to guide, that was done, and the remediation of that is complete. There's been a more broad exercise in terms of, I'd regard more as quality assurance rather than it necessarily being a mistake, that to see whether on the basis of all the additional information that's been accrued up till now, different search terms should now be gone back and applied, and that's the extensive work which has been undertaken.
Is that part of what you describe in your witness statement? We needn't go there, it's paragraph 108 and following, as part of the structural review? Or does it sit outside that?
It sits outside that.
And who is undertaking that work in relation to search terms?
Herbert Smith's and Peters and Peters.
Whilst I touch upon it, can you explain in summary terms what the structural review is, please?
Sure, if you just give me a moment, just to refresh my mind.
So it's 108 on page 34.
Thank you. Yes, I know I've made a note for myself, but I can't immediately find it. Thank you. Yes, so it's centred around the use of the electronic discovery reference model, which I've annexed to my statement, and it's checking to the best level of achievable whether all relevant documents that make up disclosure, so it's checking that to see what's been collected already, what still needs to be collected, how it's held on relativity, whether there's any potential to restructure the relativity system to enable better search functions. It's looking at how we might increase technological options in relativity, which might allow, for example, some computer-assisted searches to be done. And it's also looking at all the steps in the process, so what's done by whom, and looking at how we might reduce risks and make achievable improvements.
As part of that, you refer to the fact that the public inquiry team is presently advertising for a disclosure specialist lawyer who would engage in the granularity of the disclosure processes.
Yes.
Does it follow that there has not been a person within the post office who has been engaged with the granularity of the disclosure processes?
So the lawyers that are in the team have experience of either public inquiries or similar work, but I don't believe they have specific expertise in disclosure matters in the way that I think I need in the team. And
that disclosure specialist lawyer hasn't been appointed yet, is that right?
So no, it hasn't. So we haven't appointed someone as yet. In the interim, what we have had is 2 senior lawyers from Burgess Salmon and Field Fisher who have worked effectively in-house as part of the team since June to help us provide that extra challenge function. And the idea is that the recruitment permanently will take the place of those lawyers.
Is that new post, the disclosure specialist lawyer, as has been reported in the media, to be paid in part by reference to a bonus?
Yes.
And what is the bonus metric?
So Post Office, like many organisations, runs a bonus scheme to which its senior professionals and management are entitled to participate in, which has business-wide objectives which are set for the whole organisation, including things like financial targets. the team is entitled to take part in that in the same way that other parts of Post Office are. In the current scheme and in any future schemes, there are no metrics directly related to the inquiry.
So that lawyer and other lawyers, is this right, are not being paid bonuses that are related to their performance in inquiry work?
So I think we have to look at it at two levels. So first of all, there's a decision which is taken by the Remuneration Committee as to whether or not the corporate-wide objectives have been met, and that triggers the entitlement in principle to payment of a bonus. At a team level, as you'd expect, there are personal objectives for each member of the team which are focused on, in the inquiry team, support for the inquiry. Their performance is then looked at in the round at the end of the year, looking at what they've delivered, in what context, with what standards of behaviour, etc. Higher levels of performance could lead to the achievement of a higher bonus award, but the decision has to be taken in the first place that it's payable at all.
Lastly, and in less than 5 minutes, can we look at the hard copy document review? This is a discrete issue in the sense that it's not related to the 3 disclosure issues identified by the chair in his previous decisions, and that is the hard copy document review being undertaken by the Post Office and its advisors. Can you explain to us in summary form what the hard copy document review is?
So there was, I think after concerns have been raised previously as in the way that some of what Fintan's described about the sort of slightly haphazard way that data had been stored, there was a review undertaken of where all data, hard copy data, was stored. That was then audited by an external firm which reviewed all the sites to see what was there. That's led to the discovery of some additional hard copy material which has been produced to the inquiry. It also led to the discovery of some additional electronic materials such as backup tapes where some of the work is still ongoing.
Can we look please at poll 0012 4517? This is a letter from Herbert Smith Freehills to the inquiry of the 22nd of August that deals with the hard copy document review. And under the heading backup tapes, if we scroll down please, the author says, as set out in a previous document, in October/November 2022, the Post Office identified 42, just stopping there, I think that's subsequently corrected to 37.
Correct, yeah.
37 backup tapes with unknown contents at its Chesterfield site. So this is telling us that about nearly a year ago now, 37 backup tapes were found in Chesterfield.
Correct.
If we go over the page, please. At paragraph 7, in December and again in February, the Post Office instructed KPMG to prepare indices of data stored on the tapes. In paragraph 8, KPMG prepared a total of 91 indices. Paragraph 9, following investigation of the files, Poll decided to process the files referred to in some of the indices onto a separate dedicated relativity workspace for further examination. Is that what you referred to earlier, separating something out for a smaller scale review?
Yes.
Paragraph 10, processing the data onto the relativity workspace has taken much longer than anticipated. Paragraph 11, deduplication at the parent document level has been applied at the processing stage across the 19 data sets. There's very significant duplication as between the data sets and sessions, a reduction of 19 million documents to 4.8 million documents. Over the page, please. At 13, Poll recognises the importance of continuing to assess the likelihood of new inquiry relevant documents being backed up onto the 21 data sets and sessions. Your current plan is as follows, and that's set out in the remainder of paragraph 13. Then there's an update, please. Can we look at Poll 0012 6338? This is a letter that came last Thursday under the heading Backup Tapes. Origin of the backup tapes, as we know, they were found in Chesterfield. If we go to page 3 of the letter, please. At the top of the page, I should say in the previous page, there's a summary of some of the steps that were set out in the previous letter.
Yes.
Whilst Poll is not yet able to confirm with certainty how long these steps will take, Poll currently estimates it may take between 1 to 2 months before Poll has identified a potential review pool. This will be subject to machine time, which will be dependent on the eventual data sizes, which need to be migrated and deduplicated. Then search terms will be applied. It will take approximately 2 days to run the search terms. And KPMG say it will take approximately 2 weeks for the responsive documents to be migrated to the inquiry platform. 13, the migrated documents will then need to be deduplicated. That's essentially deduplicated against what you've already disclosed to the inquiry. 14, Poll will then assess the data that's left and consider targeted searches. And 15, given the large amount of data from these 21 data sets, further consideration will have to be made to ensure any review is proportionate, and the Post Office will keep the inquiry informed.
Correct.
And so essentially it's going to be another 1 to 2 months before the data that was discovered last October, November is even assembled into a pool that can be searched.
That's correct, but my understanding is that the steps that have been taken have been essential in order to get the data down to even any kind of manageable size so that that review could take place.
Has there been any assessment as to the likelihood that the data that has not yet been reviewed is of relevance to the 3 phases of the inquiry that have already been completed and phase 4 that we are partway through at the moment?
So as a starting point, my understanding is that by their very nature, as backup tapes, the expectation is that they won't contain new information. But I don't understand us to be at the stage of being able to work out what may or may not be relevant.
And is that because there isn't an understanding of what they are a backup of?
Yes, correct.
Finally, on the remediation exercise, has the Post Office got a target date at which it can now inform the inquiry of completion?
So my understanding is the vast majority of the work has been done. There are some further target dates over the course of September, so the 14th of September, some more on the 29th of September, but then an overall expectation that any remaining work will have been achieved in good time before hearing dates are set for the criminal case studies work.
Mrs. Wills, thank you very much.
Thank you.
So apologies for going slightly into the lunch break. I wonder if you have any questions, or if not, might we break until 2:05?
I don't have any questions, so we will break until 2:05. Mrs. Wills, thank you very much for your detailed statement and the detailed answers to the many questions put to you.
Thank you.
Thank you very much.